right, we have one more case for the morning docket, Sandy KAYE condominium case, and we get the appellant's name. I don't want to butcher it, so who's the appellant here? Are you the appellant? How do you pronounce your name? Well, how do you pronounce your name?
JEWUSIAK.
All right, Mr. JEWUSIAK versus Sandy KAYE Condominium Association. And sir, you can come up to the podium if you'd like. Sir, as you may have observed, the appellant gets to go first and last. Do you want me to set aside a certain amount of time for any rebuttal argument you'd like to make?
Yes. May it please the Court, my name is Thomas JEWUSIAK. I am the appellant, pro se. I would like to reserve 5 minutes for rebuttal in this matter.
All right, you may proceed.
This is a lien foreclosure case concerning a condominium by summary judgment. The point of my brief is that there is no competent evidence on the record that meets the requirements for summary judgment. Now, the major point I make is that the Sandy KAYE does not disprove my affirmative defenses, and there is numerous case law on that. Would you like me to summarize everything first and then go back to the cases?
It's your argument, so what you need to do is tell us why you believe the trial judge was in error in entering the summary judgment.
You can assume for purposes of this argument that we are familiar with the record and we are familiar with the briefs. We have read what has been submitted.
Okay. One of the points I make, and it was objected to, is that the original claim of lien was a hearsay document, that it was based on the hearsay affidavit of the attorney for the association, that she was not the custodian of the records for the association. She was, I hate to use the term merely, but that's what the case law on this states. She was merely their attorney, agent so far as their attorney, but not the custodian of their records. She had no personal knowledge as to the validity of the debt. There is an objection to that on the record, and the case law that I quote on that extensively is primarily Topping versus George Sank. And I think it's an important issue because everything that follows from that is in fact contaminated by the fact that that is an invalid Topping versus Hotel George Sank. The affiant is not the agent or employee of appellee with personal knowledge of the facts, nor is he the person in whose charge, custody, and control appellee's business records are entrusted within the contemplation of the shopbook rule. Further, where cases Thomas's versus Money Store, also one of the key issues is that the documents that were attached were not certified to or introduced by way of affidavit. The body of case law indicates there is in fact no competent evidence to support summary judgment. The fact that files appear and are attached and that they appear in the records of the Sandy KAYE does not make them competent evidence. Thomason versus Money Store, the affidavit in support demonstrates no more than that the documents attached thereto appear in the files and records of the appellee. This is not sufficient to meet the requirements of summary judgment. All exhibits, any files submitted by in favor of summary judgment need to be introduced by way of affidavit. They need to be authenticated. I also quote by Fulco versus State Farm. Another major thing is that there are a series of affirmative defenses that I make throughout the affidavits. One major one is that the Sandy K never did any inspections of the windows that I claimed I was responsible for. There's no expert testimony that they had them inspected. There is nothing in the records that they asked me to caulk the windows. There is nothing in the record that indicates that they needed caulking. There is absolutely nothing in the record to explain their having the windows caulked, and I think getting back to I missed one case on Ginsburg versus Northwest Medical on the fact of attaching various unsworn and uncertified documents. Only the record custodian can lay the requisite foundation. Sorry to back up on that. Without any proofs, and I quote Bifulco versus State Farm, without any proofs or competent evidence by way of affidavit or certified attachments to a proffer affidavit in the record, Sandy K should not have been granted summary judgment. I quote Fisher versus Tanglewood, which is a case of the Fifth, to the effect that the validity of assessments have to be proved. You can't simply, stick in a claim of lien, even though this is a very questionable claim of lien, saying that this money is owed without offering some proof. There's no invoice. They never even proved the fact that the work was done. There are no counter affidavits. Again, getting back to the point of the fact that I made these affirmative defenses. There's a long body of case law that each and one of my affirmative defenses have to be countered with an affidavit disproving it, that I am to be given the benefit of the doubt, that the merest possibility that I have a valid basis, a material fact that is in question, I have to be given the benefit of the doubt of that. In the absence, this is also Curtis versus U.S. I know that's a U.S. case, but in the absence of or inadequacies of counter affidavits by the plaintiff, the court may accept as true the statement of the defendant. A major thing is contract ambiguity. I don't think it's ambiguous, but obviously is, because they interpret it entirely differently. The contract is on the record. Since it is ambiguous, it is not subject to summary judgment, because it is not a question of law, it is a question of fact. But in many ways, that's irrelevant, because in the case of an ambiguous document, in condo documents or in restrictive covenants, if there is ambiguity, and there's a clear body of case law on this, the ambiguity must be interpreted in favor of the party moved against, the party who is having this enforced against. We have Snyder versus Chisholm, which covers the other entrant, but in contract ambiguity, the major case is Snyder versus Groditz. That's also the 5th District. A covenant which is substantially ambiguous is resolved against the party claiming the right to enforce the restriction, which also quotes Washington Apartment Hotel versus Snyder, Orange Gardens. We also have Shields versus Andros. They gave a definition. Their definition that they gave of closed, in fact, backs up mine. The fixed windows do not open. It is clear that this is the responsibility of the condo association. We should not look to dictionaries. In fact, we cannot look to dictionaries. Words used must be given their ordinary, obvious meaning. That's a direct quote from Shields versus Andros. Any doubt as to the meaning of the words used must be resolved against those seeking enforcement. Palmer versus Townhouses Homes of Oriole. It is clear that an ambiguity should be resolved in favor of the homeowner. This goes back to, 1925 case, Moore versus Stevens. If this court rules that it isn't ambiguous, then it has the right, because it is a matter of law, to reinterpret that and reinterpret it in my favor. That is the prerogative of this court. Another very important thing is this is a summary judgment. Therefore, this court reviews this case de novo. It goes to the record. There's ample case law that indicates, I hate to insult the lower court, that the appellate court does not owe the deference to the lower court that would ordinarily apply in a non-summary judgment case. This court has before it the same record as the lower court case, and all of the requirements put upon the lower court by case law are also the responsibility of this court. That is, the language used over and over and over again is that the court must scrutinize the record, must search the record, must give, if there is the merest possibility of a fact in dispute, that the benefit of the doubt must be given to the party moved against. We have a transcript. The record is, there's a point that was made by the opposing attorney that some of the issues I did not object to. There's another body of case law that says quite firmly that I am not limited to the pleadings, that summary judgment cannot be granted because of incompetent pleadings, that it is the record that is the most important, that the lower court and the appellate court must look to that record and must in fact forgive incompetent pleadings, as odd as that sounds. In fact, it isn't even required that the transcript be brought court, and there is a body of case law on that, because the transcript itself of the trial is in fact the arguments of counsel. And the lower court in fact conducted a trial. It's clear on the record that the court took the hearsay testimony of the opposing attorney, questioned her about facts that she had no direct knowledge of, no personal knowledge of, and based conclusions on the testimony of that attorney. And we have a whole body of case law that indicates that in summary judgment, the judge is not to weigh the facts, is not to make determinations. The key issue is there an issue? It is not my obligation. It is not JEWUSIAK's obligation to prove. It is only his obligation to indicate that they are there. And again, if I've overdone it on the case law, I apologize. Again, getting back to the point that it is incumbent upon the opposition, the person moving against, to disprove by competent evidence every single affirmative defense raised by myself. An affidavit of indebtedness in and of itself is not competent evidence in any way questioning my affirmative defenses. We have Bax versus Federal Deposit. The affidavit of indebtedness failed to disprove the affirmative defenses raised by the defendant. Most of my affirmative defenses were simply ignored. The party moving for summary judgment has the burden to conclusively refute the affirmative defenses. Again, Bax versus Federal Deposit, affidavit of indebtedness by itself does not disprove affirmative defenses. Anderson versus Rosetree, as an affirmative defense, appellants allege that the enforcement of restricted. Again, the very fact that I have the affidavits, and one important that I may not have time for, is the Judge Dugan, in taking testimony, here hearsay testimony from the opposition, concludes by saying, first of all, he concludes, he states quite openly that he didn't read my affidavit completely. He admits quite openly that he did not search the record, that he did not examine the record carefully. In fact, the language was something to the effect, of course, I didn't have time to read the entire motion in opposition. Another failure of the lower tribunal is that it did not make findings on each and every one of my affirmative defenses, and that is a requirement. Again, as a party moved against, I'm entitled to all inferences. The 5th District, this court was eloquent in Collins versus...
You're at 5 minutes now, just...
In Collins versus Brigman, that the party moved against does not have to demonstrate with clear and convincing evidence that there is a genuine issue as to any material fact. There merely has to be demonstrated that a genuine issue as to a material fact is in dispute. The language again, merest possibility, Land Management of Florida, 2nd District, 2008. Every Florida District Court of Appeal has concurred with our holding that the merest possibility of the existence of a genuine issue of material fact precludes the entry of summary judgment. Cresto versus Co. The party moving for summary judgment has the burden of establishing irrefutably that the non-moving party cannot prevail. Maggia versus Rodriguez. The moving party has the burden of demonstrating a negative, the non-existence of material issues of fact by competent evidence. Frost versus Regions. Before a plaintiff is entitled to summary judgment or foreclosure, the plaintiff must either factually refute the alleged affirmative defenses or establish that they are legally insufficient to defeat. Again, getting back to Went versus Lasky, it is the requirement of summary judgment that the lower court judge address in his trial court order each and every one of the affirmative defense, and that is also this court. That is the 5th District. We conclude, quoting this court, that the court summary judgment fails to adequately address the viability of all of the affirmative defenses, and that the court improperly placed the burden, on and on. Where the movement merely denies the affirmative defenses, and the affidavit in support of summary judgment only supports the allegations of the complaint and does not address the affirmative defense, the burden of disproving the affirmative defenses has not been met.
All right, sir, you're down to 2.5 minutes, so you only have 2.5 minutes left for rebuttal.
I can't even begin to. I've covered what I believe to be the most important issues, and that is the fact that a summary judgment was granted improperly, that the burdens, and they are severe burdens, were not met, and the fact that also a question of timing. The 30-day notice was given after the lien was filed. You can't give a 30-day notice to foreclose a lien when it's in fact filed before the lien is filed. A small technicality perhaps, but something that has to be considered from this court. There was in fact no 30-day notice after the lien was filed. Again, getting back to the fact that the judge conducted a trial, Hernandez versus United Auto, it is well established that the court may neither adjudge the credibility of witnesses nor weigh the evidence. If this court reads that trial transcript, which I brought forward, it is quite clear that that was the attempt of the judge, was to weigh evidence, hearsay evidence, because there is no evidence on the record. Again, I quote extensively on de novo review, but that's perhaps something that doesn't need quoting. It simply means that this court has the obligations of the lower court to scrutinize the record, to study the record, and to make determinations based on that. and that, again, that it owes little deference to the lower tribunal in this matter.
Okay, if you want to save any time for rebuttal, you're down to
Okay,
35
yes, I
seconds.
definitely did.
All right, you have 34 seconds for rebuttal.
I didn't realize I was running into my 5 seconds for rebuttal. I apologize, Your Honor. It's been an honor. Thank you.
Okay, thank you.
You can have a seat at council table.
Right there, Phil.
May it please the Court. My name is Liliana Farina Sabogal of Becker and Polyakov. We represent Sandy KAYE Condominium Association, the appellee in this case. Your Honors, one thing that the appellant did not mention is the paramount issue in this case before it, which is that the position he has taken in his reply brief for the first time, that the summary final judgment entered in June of 2009 is a non-final interlocutory order, and that the order that is currently before this Court, which is the December 2nd, 2009 order rescheduling the foreclosure sale, is the final order. It's not tenable either legally or factually. What is currently before this Court and what this appeal is limited to is the December 2nd, 2009 order rescheduling the judicial sale after foreclosure final judgment. This Court recently noted in the
So
case...
is the notice of appeal timely as to the third amended final judgment?
It was appealed prior to the entry of the third amended final judgment.
So that would mean it would be premature, which means that we could consider it.
Well, Your Honors, there's case law to support that successive judgments that don't change the merits of or the substance of the judgment don't count for appeal.
Terry, why don't you go ahead and just address the merits as far as the summary judgment? We understand your argument on the dismissal, but why don't you go ahead and address the merits briefly?
Okay. Should I address the merits of the order rescheduling the judicial sale?
No, you don't need to.
Okay. Your Honors, the association's position, as you noted, is quite clear that this Court is not jurisdictionally able to review that final summary judgment because of the timeliness of the issue. But even if it were, the final summary judgment was meritorious and it was properly granted. Among other things, the appellant's arguments were not preserved for appeal. In order for, obviously, the issues to be heard on appeal, they must have been preserved in the lower court. Although difficult to follow, the appellant's filings raise a number of issues which he went through during oral argument. The first one that he mentioned is the claim of lien and whether the claim of lien was valid or not. I'd like to point out that at the outset of this case, appellant was represented by counsel who set forth numerous affirmative defenses, none of which attacked the claim of lien in this case. The reason for that is because the claim of lien was properly signed. Florida Statute Section 718.116 specifies that the association's agent and the association's attorney was acting as its agent can sign the claim of lien, which it did. She was not signing the affidavit of indebtedness, which later supported the foreclosure case. That was filed by the association's custodian of records. But the claim of lien was valid in that it was signed properly by the association's agent. Again, that issue was not raised below, and in fact, appellant did not raise this issue until after the entry of the final judgment. The affidavits of indebtedness are competent evidence to support final summary judgment. The Florida Rules of Civil Procedure are clear on the point that affidavits constitute competent evidence. Again, whether they were or whether they were not competent evidence was not an issue that was raised below. At no time during the hearing was this raised. And in fact, if one reads the affidavits of indebtedness, and there were a couple entered in this case, not only does it submit that the claim of lien numbers were correct and valid, but it also verifies the allegations in the complaint, which detail the facts upon which this case was based. So the affidavits in this case do constitute competent evidence to support the final summary judgment. The association did establish the validity of its assessments, again, through the affidavits of indebtedness, which improperly titled, I suppose, because they were just affidavits supporting not only the indebtedness itself, but also the allegations that were contained in the complaint. the appellant never challenged the validity of the assessments. Never did the appellant say that the association did not have the authority to pass the assessments. Never did he claim that proper notice wasn't held, that there was some procedural deficiency with the assessments. At no point in any of his multiple affidavits, at no point in any of his opportunities before the court, and the filings are numerous, as you can see by the size of the record, at no point was there ever an assertion by the appellant that the assessments at issue in this case were not valid for any reason. In fact, at no point did the appellant allege that he paid the maintenance that was which was proven to be delinquent in this cause. So, appellant never challenged the validity of the assessments, never challenged...
There were two things. There was a special assessment, is that right?
That's correct.
And there was ongoing maintenance, both of which were unpaid.
Correct. In fact, there were several assessments at the time, but what was ultimately leaned for and what was ultimately undisputedly unpaid was the special assessment for the window caulking.
Directed to his unit 901?
I'm sorry?
Was it a special assessment directed to his unit?
Yes, Your Honor.
901? It was for the caulking?
It was only, the special assessment was specifically for the caulking.
Right.
And then there were maintenance payments, the regular assessments, which were made unpaid, and which he never alleged he paid, which he never alleged there was a reason why he shouldn't pay them, never alleged they were improperly assessed. At no point was there any allegation regarding this. The appellant's assertion that the question of the declaration and the interpretation of the terms of the declaration is an ambiguous one. Your Honors, it's interpretation of a contract. It's plain language. The appellant is directed by the declaration, as are all owners, to maintain the units in their, the windows in their units. It doesn't specify there the windows that swing open and close, that slide open and close, not fixed windows, only these kinds of windows. It just says windows. And so the association's point is at no point, again, was there any need for a construction of the language. It was plain language, which was that the windows were to be maintained by the appellant. His claim that there was never any evidence that the windows actually needed caulking are belied by his own affidavits. In the record, on a number of occasions, he has parts of his affidavits include exhibits wherein he states that he demanded on a number of occasions that the association caulk his windows. Therefore, he himself was admitting that the windows needed caulking. He also did not do the caulking and did not dispute that the association did the caulking. The association's declaration clearly gives it the authority to perform the work and levy an assessment if the work has not been done. That's what happened here. None of that was disputed.
I thought he did assert that he had caulked the windows.
He did not assert that he caulked the fixed windows, which he has maintained were not his responsibility. Again, the appellant never showed that there was a material fact in dispute. To date, he still has not, although he was able to cite a number of cases proving or setting forth the notion that a genuine issue of fact, even the merest possibility of a genuine issue of fact was in dispute, would prohibit summary judgment. He's never verbalized in any of his filings or in any of his briefs or before this court just now, what is the genuine issue of material fact? What is in dispute here? There's no challenge as to the validity of the assessments. There's no question that he didn't pay the assessments. There's nothing left. This is a simple lien foreclosure case. The association has the authority to levy the assessments. The assessments were levied. The assessments remained unpaid. A summary judgment was proper. There was no hearsay evidence in the summary judgment. The court, I'm sure, has reviewed the transcript, which is part of the record. The only testimony that the appellant claims was given was that which is already contained in the record. There was no new information that was given, and certainly it wasn't anything that the trial court relied upon. The file, as the trial court noted, it did note that it had reviewed the file. It is not true that it said it had not reviewed the file. What the trial court said was that it had not been given the opportunity to review the 85-page affidavit that the appellant filed 2 days before, untimely, 2 days before the hearing on this motion. However, if one looks at the affidavit that was filed prior to this affidavit, it is almost a verbatim copy of the same affidavit that was filed before motion for summary judgment. Therefore, the allegations in that affidavit had already been reviewed by the court. the appellant raises in his brief that he was unable to complete discovery prior to the motion for summary judgment. Your Honors, this case was filed in 2006. The motion for summary judgment was heard in 2009, 3 years. He had plenty of time. Yes, there was a change in his representation in 2008. His attorney withdrew as his counsel, but that was still 2 years where the case was pending that discovery could have occurred. And further, it was 1 full year after the withdrawal of the attorney where discovery could have occurred. The appellant has proven himself to be quite able in terms of reviewing what's necessary to be filed and how to get around the court system. Certainly, he could have asked for discovery if that's what he wanted, but he never did. Not one request for production, not one request for interrogatories, no depositions were noticed, no effort whatsoever was taken toward moving this case towards discovery. So to claim that he was not given the opportunity to conduct discovery 3 years after it was filed is disingenuous at best. Notwithstanding that, in January of 2009, the trial court issued its trial order noticing this case for the March 17th trial docket. Therein, it advised all the parties again that discovery had to be completed 2 weeks before the trial docket was to begin. So he had until March 1st, following a January 15th order, so a month and a half, within which, had he felt the need for discovery, had time to propound the same and receive the responses to the same or to seek persons for deposition. None of that was done. One of the other arguments that's raised in the in the appellant's brief is that he was improperly denied the jury trial. As Your Honors are well aware, this is an equitable matter of foreclosure. He's not entitled to a jury trial. And notwithstanding that, even if he were entitled to a jury trial, if there was no genuine issue of material fact, this case could have and was properly decided on summary judgment. The affirmative defenses, which the appellant makes much ado about. The affirmative defenses, as I noted, were filed by his attorney when he was still in his employ back in 2006, I believe. There were about 9 affirmative defenses. All of them rotated between waiver, estoppel, and unclean hands. There was absolutely not one factual allegation in these affirmative defenses. Bare legal conclusions without the facts do not make for sufficient affirmative defenses. The association submits that the demand letter that he's claiming was improperly filed was by statute required to be filed and sent to him 30 days in advance of the filing of the claim of lien. It was done that way. There's nothing improper with that. That was one of the bases for his affirmative defenses. He claims that the windows are not his responsibility in his affirmative defenses. Well, that's a matter of law. That doesn't raise any questions of fact, and the trial court was well within its rights to address these matters of law, and it did properly. He claimed that the association failed to maintain the common elements and that the association, the appellant was entitled to a set-off as a result. Well, it's well-settled law in associations that failure to maintain the common elements is not a defense for maintenance payments. If there was a concern with the association's failure to maintain the common elements, he had all the right to file a different case and litigate the issue of whether they actually failed to maintain the common elements as they were supposed to, but he is still bound to make his maintenance payments. The case law is clear on that, and in fact, the appellant did take the opportunity to file a separate litigation, which did question whether the association properly maintained the quote-unquote common elements. That case was litigated to trial. All of the issues that the association has had to defend itself in this particular foreclosure case were litigated in a separate case. The trial court below very clearly makes note of this, very clearly asks the appellant, are these issues being litigated in a separate case? And the appellant admits that they are. His affidavits say that the actual heart, the crux, the critical issues of water intrusion are being litigated in a separate case. So when this trial court enters the final summary judgment, as it did so on the bare notion of the assessments were proper, they were properly adopted, they were properly levied, and there was no payment. That is all that there is to this case. All of the issues that the appellant wishes to interject. First, of course, the association maintains they're not timely, but besides that, they were segregated into a separate case.
Thank you.
Thank you.
Is there anything else?
All right, sir, you have 34 seconds.
Included within the responsibility of the apartment owner shall be windows, screens, and doors opening into and onto his apartment. It's quite clear that opposing counsel has not read the record. I am not limited to the pleadings of my attorney as far as affirmative defenses. The most important documents are the affidavits that I filed in this matter, the affidavits on the previous summary judgments, and the affidavits that were filed prior to this. I am not limited to the pleadings of my attorney, and if he was lax. Also, as far as discovery, there is in the record that I asked for discovery, and I was denied.
So your time is up. Thank you very much.
Thank you very much.
Our decision is issued in writing, so when after we conference and issue our decision, you all will get a copy of that.
Thank you very much.
Thank you all very much.
All right, we'll be adjourned.